Welcome back. You're watching The Firm. Now, on the face of it, it's a decision supported by commercial rationale. Simply put, Adani Power asked for tariff revisions in its contracts to supply power to Gujarat and Haryana power utilities based on an increase in the cost of coal due to a change in law in Indonesia. That is the country that it sources its coal supply from. Now, the CERC denied that the change in Indonesian law amounted to force majeure, but granted frustration of contract on grounds that if the price escalation is on account of some event which was beyond the contemplation of the parties, in this case Adani Power, then the impact of price variation needs to be duly considered and addressed in order to enable the parties to continue to perform their obligations under the contract. The CERC went on to say that Adani Power needs to be compensated for the intervening period with a compensation package over and above the tariff discovered through competitive bidding. It's meant to be a variable compensation package, and a committee will be set up to decide on the increase in tariff. As the CERC says, this may be a pragmatic way to make the PPAs workable while ensuring supply of power to consumers at competitive rates. But in doing so, the CERC may have opened the floodgates to contract renegotiation in any and all such instances that involve the government. To discuss exactly that point, I'm joined by Gopal Jain, Supreme Court advocate, and Dipesh Deepu. He's partner at energy consulting firm Genesee. Gentlemen, to both of you, a warm welcome. Gopal, my first question to you. Do you think that the CERC has made the best of a bad situation in the power sector, a pragmatic decision, as the CERC calls it itself? Or do you think that this decision sets a very poor precedent and leaves several contracts which have the government as a party vulnerable to renegotiation?
I think let me start by saying it's a high energy order. The mood in the sector was you required a boost or a fillip, and the fact that the CERC has looked at the larger interests of the energy sector as a whole, has taken a pragmatic view and given what I call a forward-looking approach and a perspective to this matter. So I think as a start we should say that look, they have applied sound regulatory principles and have given some meaning to compensatory variable tariff, and yet at the same time they have taken care to say that this is for a provisional or an interim period till such time as this problem is there. As you rightly said, this does also throw up certain issues about the sanctity of contracts and this whole bidding process. But I think as an opening comment I would like to say that sensing the mood of the hour, I think this is a fairly forward-looking and pragmatic decision that they've taken.
All right, Dipesh, would you also term it as pragmatic, given that Adani had the opportunity to quote escalable charges? In other words, it could have kept the fuel price as a variable charge in its bid component, as did other bidders. Instead, it quoted fixed prices for 20 years, knowing fully well, as a company in its position that would do, that fuel prices come laden with uncertainties over such long periods of time. Prices are always subject to change, and countries often do impose additional costs, taxes or levies when it comes to resources. So did they really deserve this relief?
We have seen that in the past there has been cases of resource nationalism, and in Indonesia that has really happened now. So I would say that possibly there was a fair degree of aggression in terms of considering that they would be able to control the mining costs all the time. And that's not very unique also to say that there have been several case 1 and case 2 bids, particularly based on the imported coal sources, where such calculations have been done by several other bidders also. So as this decision has been taken for a compensatory tariff, the apprehension that there will be a queuing up of several of these case 1 and case 2 based bids is going to turn out to be true.
Okay, so you're saying that in a very sanguine fashion. Let me reproduce what the dissenting order said, because the majority order was backed by 3 members. The dissenting order was written by 1 member, and that member has gone out to call Adani's bidding aggressive and predatory. And he has also said that the petitioner, in the face of these Indonesian regulations, cannot renege on its commitment and seek restitutionary remedy in the form of additional tariff. Gopal, you want to reconsider your opening comment as to this being a pragmatic decision, because it seems clearly this is a decision that favors Adani's predatory pricing mechanism in a bid.
Menka, let's balance 2 things. One, you have to see the judgment for the signal it sends to the sector as a whole. So there is a larger perspective, a larger dimension, and a larger interest. If you remember in the Vodafone tax case, the Supreme Court gave a big boost to investment and gave it a pride of place, by saying that, look, capital goes where investment is protected, return should be ensured. So you've got to see the flavor of what has been said in this context. And yet, as you said, there is a counterpoint, which is why you have 3, 4, 5 members, experts who consider, and that view was in a minority. So it's not that the view was not considered. It was considered, but 3 people felt that they would take one view, and this was a minority view. But the view taken, as well as the fact that, as Dipesh rightly mentioned, there will be these aspects which will come up. It will be like a case of sour grapes for some of the other persons who, if they had a chance, would have said, look, we could have then redone our bids. So there are those aspects too. But as I said, sometimes we must savor what comes at the time that it comes.
All right, we do have the Adani lawyer Vikram Nankani now joining us, previously held up in traffic. On the face of it, it's a decision that comes with commercial rationale. Right. But it's patently unfair to those bidders that were not as aggressive as Adani.
I think this needs to be put in perspective. On one hand, you had a national coal distribution policy. Clearly, that policy held out to the investors at large that if you come into the private power sector, we are here to back you with 100% coal allocation or linkage.
It doesn't matter. In both these bids, Adani offered MOUs signed with German and Japanese companies for the import of coal in the first instance.
Yes, there are 2 parts to this case. One, in Haryana, there definitely is an indigenous component. And I'm again talking of this in the context of the law that we have pleaded, and that has found favor with the 3 members.
Fuel supply was not the responsibility of the utility.
It is so. It is so.
So why should the utility bear the higher cost and eventually consumers bear the higher cost because Adani did its math wrong?
As I said, it's an amalgam of various factors. After all, doctrine of frustration is a well-recognized, globally recognized exception to the law of binding contracts. So this provision is pretty much the part of the same contract law of which we are talking about sanctity. So this, if you have a case which post the contract results in impossibility of performance, you're not going to have an asset sitting there which becomes an NPA with lenders with more than thousands of crores at stake, allowing it to just perish. And by the time you build fresh capacities, what are you going to look at? You're going to look at a consumer paying 5 rupees to 7 rupees.
Why are we even talking about fresh capacities? Let me quote the minority order to all 3 of you. Yes. And it's very clear here that it is not the job of the utility to bear the additional cost. If the contract has now become onerous upon the supplier.
Let me correct this. It's not an Adani specific issue. It's an
We're talking about an Adani
issue.
situation and decision right now.
Undoubtedly. But this decision is universal in its application to the power sector.
It doesn't say anywhere that it is universal and applies to similar other situations as well.
We know that there are other matters.
You may know that, but the order doesn't say so.
No, we are saying...
the CRC knows that as well, but the CRC in this order has at least not specified that this applies to all other similar situations.
But let's not shy away from the fact. Let's not shy, because this is something of which is reported, well reported in media. There have been representations made to the PMO's office. There have been a large number of matters which have been taken up, and they are still pending in CERC.
All right. Dipesh, I'm not just concerned about the fact that this opens up the floodgates and makes all such contracts where the government is party vulnerable to renegotiation, but I'm also concerned about the fact that this could make the grounds for renegotiation fairly fickle, right? Because in this case, Adani should have been able to control its fuel pricing, and if it didn't, it was a risk that it should have borne. Instead, now other suppliers will be able to pass on this risk to the utilities.
Yes, I agree, and I think not just the principle about the renegotiation on the contracts which have already been signed, but also the difficulty of arriving at this compensatory tariff itself. Now imagine there are so many complex special purpose vehicles that are used for investments, and mining in Indonesia is typically very different from what we do here in India. Now, how do we arrive at the cost which are prudent, the capital costs that are allowable, the dividend distribution policy if the investment has been through a portfolio or through holdings, and then calculate that back all the way to the Indian subsidiary of some ultimate parent to arrive at what should be the compensation. So I think from the procedural point of view also it's going to
I'm glad you brought that up. I'm glad you brought that up because the minority order, which is a dissenting order, alludes to that.
Yes.
Go ahead, make the other point.
When we look at all this and say that this is going to be a temporary measure, I think there's a fundamental flaw there, because since 2003, the volatility in coal markets in the international arena has been very high. So I'm sure this is not a temporary process. What CERC has in turn done is that it has taken a competitively bid project and put it onto a cost plus kind of a measure, and it will continue to happen till the end of the life of the project. So that's going to be another big challenge.
And that is a step back in time. I'm going to give you an opportunity to respond, Vikram, but I want to go to Gopal on this one. That is a step back in time, Gopal, in the way our power sector has evolved over the last several years, you would admit. You also did agree right at the beginning that you thought that this would lead to more contract renegotiation. So that is the final question I'm going to put to you. What does this mean for all those contracts where the government is a party? Are we going to see several more infrastructure players, whether they're port players or road sector players, come by and say, hey, I wasn't able to fulfill this aspect of the contract, or there's been a cost escalation for reasons beyond my control that could lead to the frustration of this contract, and hence you must allow me to increase the price?
So, three things. Does it give, is there a solution here and the solution outweighs the problem? One way of looking at it. Second, it's not that this is the only case of contract negotiation. I have looked at issues in the airport sector and the telecom sector where this exactly similar issues have come up. The road transport sector you mentioned, two major projects are currently under review. There is some renegotiation. So like I said, and Vikram also said, you have to see the context perspective where a particular sector is. Can you give it a fillip? Can you give a larger signal which goes beyond Adani? But sure, that the fact that there is such an order and there is a sort of variable tariff by measure of compensation for a stopgap or an interim period, as a principle or a precedent, it could be applied to other persons in this sector, it could be borrowed by other regulators in other sector. That is certainly a possibility, because as you know, that good practices in India, regulatory best practices, are always replicated. One just borrows from the other and applies the same principle. But just to end by saying, I see this more as providing a solution than creating problems.
As you know, that the standard bid document has now been amended. Fuel has been allowed as a pass-through in all future standard bid documents.
So we may not come upon this situation again. All right,
that's
fine.
a result of a big learning curve which was there. There was a phase where this industry was trying to learn to come to grips with what the real tariff would be. And now you're talking of consumer interest. If you look at it, what happens if all this capacity, it perishes? Therefore, what the regulator has done has not taken a very pedantic view, has tried to take a larger view whereby it has balanced the interest of both the generator and the consumer.
And yet the minority decision says, considering the intercompany transactions agreements with the group or the conglomerate, that's the Adani group, affecting transfer price of coal, it is difficult to calculate loss or gain for a particular company. The increase in price of coal directly benefits the Indonesian company, which benefits are passed on to Adani Enterprises in the shape of return for the investment, and thus the Adani group as a whole may be the ultimate beneficiary of the Indonesian regulations.
Unfair for me to comment on that.
Unfair if at the end of all of this, it is the consumer that pays for the gain that Adani enjoys.
Let me tell you, the wisdom of the majority will prevail.
Gentlemen, to all three of you, thank you very much for weighing in on this debate. With that, we're out of time. Thank you very much for watching. We'll be back next week.